I want to call to order the special meeting for August 16th, 2013. Madam Clerk, would you take the roll for us, please?
Yes, sir. Mr. Hall.
Present.
Mr. Trombley.
Here.
Mr. Birch.
Yes, on the phone.
Ms. Tembowski.
Present.
Mr. Flynn.
Excused, he may join us later.
Ms. Gray Jackson.
Honored to be here.
Mr. Honeman. Ms. Johnston. Mr. Stark.
Mr. Starr is excused.
Mr. Steele.
Here.
Mr. Traney.
Here.
You have a quorum.
Thank you. Ms. Gray Jackson, would you please say the pledge?
Certainly, Mr. Chairman.
It's over here around the corner.
Sorry about that. Come on this way, y'all. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our order of business this morning is item 4A, a presentation from the Municipal Law Department on the NALA, North Anchorage Land Agreement. Mr. Wheeler?
Mr. Chairman,
Floor
thank
is
you.
yours.
Thank you. First, my apologies to the group. It might be easier if you actually tear apart the blue folder. Looks like my staff didn't leave enough margin there. It might be a little easier to look at the docs if you pull them out of that folder. The presentation I have for you is actually fairly brief. And what I tried to do is get right to the crux of the issue between us and Clutna. While it is true that there's an extensive history here in terms of native claims settlement, land allocations, and entitlements, the fact that between the municipality and the Clutna, there's a significant amount of land to which they were entitled, which could not be satisfied in the Anchorage Bowl because of private inholdings in federal and state land acquisitions that were already present, and thus the birth of NALA to use this federal military enclave as a potential source of lands for both community and Clutna. But I'm not a historian, I'm not going to spend a lot of time there, but recognize that there's an extensive history there. Also recognize that Alaska is a resource-driven state, and that informs part of my conversation about the language at issue. And the language at issue is on the top of the very first page that I've given you, which comes straight out of the North Anchorage Land Agreement. Net income properly attributable to the land as opposed to any improvements constructed thereon. You'll note behind that document there are going to be a number of letters between the Department of Law and Clutna's counsel that spend some time going back and forth staking out the legal position regarding that language and the agreement itself and how that informs that language. The crux of the issue is whether or not the landfill gas is a product attributed to the land versus a product attributed to improvements constructed thereon. What the courts would do in looking at this language under current Alaska law, which I've outlined in this first 2 pages, front and back, is not only look at the agreement, but look at whatever other information may inform the court's decision with particular delicate treatment of testimony regarding what people may have thought it meant at the time. The court's going to allow people to talk about what they thought it meant, but also at the same time recognize that statements you make now about what you thought it meant then, that might appear to be self-serving or probably not going to get as much weight from the court as evidence and statements made at the time that the agreement was entered into. So that'll be an interesting debate between us and Clutna about what this language meant if we're not using the definitions that are commonly used for the language here. That is the improvement out there the sole source of the generation of the landfill gas? That's our position. Or is the gas and the income derived from that gas attributed to the land, which is more in line with the Clutna's position? From our perspective, we built the improvement being a hole in the ground that's specially lined. that has all sorts of facilities associated with it to manage the input and to manage the output, which in this case includes the gas. That is all part and parcel of the landfill operation, that under federal and state law, we have an obligation to manage the output, that is the gas, that if we weren't using it in this manner, we'd have to flare it under the regs that apply. And so it's, it's as big as the issue is in terms of both the money at stake and the relationship that's involved here and the history, it really boils down to this one sentence: how do you characterize landfill gas? I would note that if you look at the back of that page, the very bottom, the full phrase contains another portion to the sentence. And I'm going to spend a little bit of time talking about that as well. It says, nothing in the sentence shall be taken to require sharing of reasonable user fees, such as airport landing fees or other usual governmental fees and charges for the use of admittedly public facilities on lands. Our read is that is not a limitation in the sense that those are the only kinds of income that do not have to be shared with the pollutant. In other words, there's an acknowledgement in this agreement that those kinds of user fees are clearly not income attributed to the land. It doesn't prevent other kinds of income from being related to the improvements, such as the landfill gas. That's our position. We have spent, as you know, quite a bit of time on this project, starting in as early as 2004, but certainly in the mid-2000s, there were a series of initiatives to look at what to do with the gas. This body was instrumental in allowing SWS to apply for a grant from the state to explore and help develop the facility. This assembly was instrumental in looking at a potential relationship with NEA, which this assembly turned down in 2009. This body was instrumental in some work sessions related to the RFP and the award of the contract to Doyon. And we continue to expect you'll be involved in however this project may form and shape itself over its lifetime. That's pretty straightforward. I don't think there's any mystery there that we're talking about what does the specific sentence mean to both sides.
Any questions from assembly members? Ms. Dabowski?
Thank you, Mr. Chair. Mr. Wheeler, as I read NALA, I clearly have the takeaway that if there's going to be development on the military base, that there should be a management plan, or Eklutna should have been part of the discussion. Did that happen? Or am I reading it wrong?
There's a mechanism by which both parties can arrange for and have conversations about what they would like to do with lands, including all the lands. In this particular instance, the take was because we had originally explored looking at lease arrangements and other things that may have created a situation where the NALA provision regarding notification of planning would have been more directly triggered. But in this case, we didn't pursue those alternatives. All we were doing was using the landfill gas. So I believe it's our position that no, there wasn't any special requirement here to notify equipment.
I'm confused because the plant was built on the military base, correct?
The power plant?
Yes.
But Mr. Magnet, that's correct.
The plant is built on JBR land, that is correct. Now, that's something that came out after the proposal came out, so it wasn't part of our planning process.
So,
If you could just identify yourself for the record.
Oh, for the record, my name is Mark Madden. I'm the engineering manager for solid waste services.
and I don't know how I should pursue this line of questioning because I have.
Well, we may need to go into an executive session. We've made arrangements.
I'll hold off on some of my further questions.
Ms. Grayjack?
Thank you, Mr. Chairman.
Mr. Wheeler, you talked about interpretation and the way the municipality interprets this paragraph, and obviously the Kootenai interprets it a different way. What I would like to see, because I don't see it here, is that email from Mr. Madden to Ms. Oswald, because I'd like to read it again. It was really hard, reading it from visual after the last meeting. And I would like it pretty quick, like in the next 10 minutes. Thank you, Mr. Chairman.
Thank you. Anyone else? Mr. Wheeler, it would appear that Ms. Dembowski has some questions that probably should be asked in the executive session. So would you like to set up the premises for us to do that? And I'll have Mr. Fonda make a motion.
Let me ask a question in aid of that motion. Ms. Dembowski, are you going to want to inquire as to what we think are the pros and cons or legal strengths of our position, or our estimation as to the risks associated with this litigation, or the exposure, or
Well, my question.
strategy?
My questions will directly be as to whether the city violated the North Anchorage Land Agreement by not engaging.
Well, the answer is our position is no, and I don't need to go to executive session to answer that question.
Okay. Well, if I may, then I'd like to just continue on. Thank you, Mr. Chairman. So as I read page 18 and 19 of the North Anchorage Land Agreement, I just don't understand how the city is sidestepping the fact that it clearly says when development happens on these properties that the municipality and Kootenai are obligated to work together to come up with a development plan. Was there a site development plan? And if it wasn't developed, there's positions in here that says if a site development plan isn't required, then there's other steps. But I want to know, if it wasn't developed, how did you identify those other steps, and what were they? And where are they notated? What documentation do we have?
Sorry, you're referring to page 18 and 19 of NOLA?
Mm-hmm.
18 and 19 refers to a conveyance provision under subsection E and a management agreement for tenancy in common under F. I'm sure you have the right sections.
Yes, and so my thought is the city saying because it was never formally conveyed, they had the right to do this without engaging in a development plan?
Under the provision, it says that in the event of any of these lands are sold, leased, or rented, or otherwise put to an income-producing use, Kootenai shall be entitled to 50% of the proceeds.
Correct.
If the net income is properly attributable to the land and not the improvements. If that's not triggered, then there's no requirement to provide the net income to Kootenai.
I see where you're going with that, but my question is, because I don't think I have the expertise to decide if it was, developed or not. That's where it's coming from. But what I am asking is, there's a separate provision talking about development of those lands.
So if I can refer you to our March 15 letter to Mr. Featherly. I believe you'll see some discussion in there about the notification issue, which I think is what you're getting to. Let's see here. Sure, I'm sending to the right letter, actually. All right, I'm sorry, let me refer you to, I was referring to the wrong one. It's the January 4, 2012 letter. Maybe you were thinking of section 19 about committee in terms of informing each other. That's what you're talking about?
Yeah,
Okay,
sorry,
so-
I was saying page 19.
Yeah, right. Sorry for the confusion there. Our position is that provision isn't triggered. And this letter explains why.
Mr. Trumbull?
Mr. Wheeler, is it the position of the city then that you have the land and that the waste, the garbage put on top of the land that is what is producing the income stream, not the land itself? And since it's the garbage through the chemical breakdown process that's creating the gas, that's why you or the city feels that there's no entitlement, for lack of a better term, that should go to Eklutna?
Yes, sir.
Okay, so, and maybe I just don't understand NALA properly. I've done my best to read through it. But if that land were vacant and the city was to put a sports arena on it, or if somebody was to, say, purchase that and they were to sell it to a private company or however it would go, and then there was a commercial building and there was a property tax value associated with that building, would Eklutna be entitled to 50% of the property taxes? Or if there was a sports arena, whatever concessions were sold in the sports arena, would NALA then apply to, in that situation, would they get,
Through the chair.
like the Performing Arts Center or whatever?
Through the chair, Mr. Trombley, I have not analyzed whether the taxes themselves would be considered income, but in the scenario you described where we sell the land or lease it, certainly the sale proceeds or the lease payments under that scenario sound like they would be something that we would share with the group.
Okay, so what I'm a little bit confused on is that if there's a lease on the building that's tied to the land because it's built on the land and the proceeds go to Eklutna, what is the difference between putting garbage on top of it and that becoming an income stream? That's where I'm confused. A building versus garbage, either one, Eklutna didn't build it, but it's still producing some sort of revenue.
Right, I understand. So again, all I can do is refer back to the language that talks about,
Is that in this letter or is it in all?
it's in the lands are sold, leased, or rented. Those are clearly triggers, right? It's when you start getting to otherwise put to an income-producing use, and the other net income is probably attributable to the land versus opposed to the improvements thereon that you get into the issue, right? When you think about Alaska as a resource state, at the time this was formed, this whirling around, getting native claims settled, getting the land allotments, entitlements taken care of, and getting the pipeline done, and so on, people are thinking about things such as timber and natural gas and gravel and so forth. Clearly, if you're talking about timber and gravel and natural gas, you're talking about resources that I think any court would find are attributable to the land and not an improvement.
So
those are easy examples to
Right.
think about.
So that's where the city feels as though that phrase, put to an income-producing use, is excluded in this situation. Or because it isn't timber, coal, oil, gas, it's not a natural resource, which I guess it could be argued that maybe garbage is a natural resource considering that.
Right. In this case, the
But-
landfill gas is, in our opinion, attributable to the fact that we built this pit and put in material that creates the gas versus drilling a hole in the ground and the gas comes out of the ground because it's naturally occurring.
Okay, that's all.
Thank you, Mr. Chairman. Last question, just out of curiosity, is there a NALA committee that meets quarterly?
There's a mechanism by which Eklutna and the Muni can get together. Can't remember the date of the last meeting. I think either side can call and ask for the meeting at any time.
Thank you.
Anyone else?
I do.
Mr. Trumbull?
You know, one of the things I don't want to do is, Eklutna is a good partner with the municipality. They've been good to the municipality. It's been a great working relationship. Is there a way to avoid a lawsuit, or as Curtis said, a friendly lawsuit, which I don't think exists, but is there something that can be done that we don't have to go to court? Or is this something that you feel has to be dealt with in court?
Ernie?
I just don't want to go down the road if I don't have to.
I understand.
They're,
I don't see the two legal departments, if you will, changing their opinion on what the language means. That doesn't mean that their clients can't find other ways to resolve the issue if they want to, if they see a need to. But we're talking about a substantial amount of revenue generated over a significant period of time, so it has value and meaning to both sides. So to meet their fiduciary obligations to their constituencies, they're not going to readily surrender it unless there's some value in doing so for both sides. What's the long-term value of the relationship and how is that best resolved? That's a difficult question.
so there's nothing that precludes the municipality and Eklutna from finding an agreement outside of going to court just because if there is a lawsuit filed.
That's correct.
Okay, I got you.
Mr. Trainee?
Mr. Wheeler, could we get a copy of both memos from Mr. Madden before we leave the room today?
I'm sorry, both?
I need a copy of the memos from Mr. Madden
The
before we
emails?
leave the room today,
Certainly.
if you would. And have we asked geologists to look at the landform to see if the landform itself lends itself to collection of gas? Because you've got different landforms. If you had the garbage pit put in a flat area, it may not lend itself to collection of
I'd have
gas.
to refer that to SWS. I don't know the answer to that question.
One thing I would point out is that between the waste that is producing the gas and the ground is an impermeable membrane. 80 mils of high-density polyethylene and about a half an inch of bentonite clay, both of which would preclude gas from migrating either in or out. It's a barrier.
So there's nothing special about the landform there, the fact that it's a pit that allows it to collect the gas?
No, other than the fact that we built the landfill there. Thank you.
Mr. Jackson?
Thank you, Mr. Chairman. Mr. Real, I appreciate your presentation and the copies of these documents. But about 10 minutes ago, I asked for a copy of that memo or email, and I'd really like to see it. So is somebody working on that?
Well, since you just made the request, no, I haven't.
No,
done my
I mean,
share.
well,
I can certainly go run upstairs and get the
Well,
emails. We
well,
gave
you
them
have
out
them.
to the
There's-
news media here recently.
I'm not trying to give you a hard time, I'm really not. I just really want to look at it again, because I may have some questions during this meeting
Sure.
regarding that memo, and that's the only reason why I asked. Thank
None
you.
of my staff are here present, so I'll have to go upstairs and get the emails and bring them back.
Thank you,
Mr.
Mr.
Jackson,
Chairman.
if you would like to see that, and Mr. Wheeler, if it is available, I will do an at ease we've got time for 15 minutes,
I would appreciate that, because I want to see it.
10 minutes? Yes.
Mr. Wheeler, can you just give me, what is the amount of revenue that's been generated from this methane project to date?
The first payments have just come in. Mr. Madden might know the amounts received to date.
And I'm happy if you get that number during the Eddies too.
Well, I may be able to answer right now.
I believe, and I don't have the numbers directly in front of me, but I believe that we've actually received payments for $600,000 to date, and there are some outstanding payments.
The budget is 1.3 million.
I can't hear you.
The budget, the expected annual revenues is 1.3 million.
Okay. Thank you, Lucinda.
Gross revenues.
Gross revenues.
Mr. Trini, do you have a question before I do an at ease?
No, go ahead, I have a question when we come back.
Okay, we're going to do a 10-minute at ease while we're able to.
Thank you, Mr. Chairman. I'll call back.
Thanks, Mr. Birch.
I'm new in town, so I just want to. I'd love It rained for the first week. Yeah, that's why I wasn't.
What I'm saying is it from the top? It's over Well, I don't know if that's true. That's what
That's why I'm like,
City council will be my lead, so I just wanted to introduce myself. Emily Carlson, yeah.
nice to meet you. I mean,
what else is there? Just what?
So GCI bought KTA, so we're kind of in the process of, we haven't gotten that to see approval yet, so yeah, we won't go on the air until late September, so I have some time to meet everyone.
Try to get
I just moved here a week and a half ago.
Where'd you
so-
move from?
Iowa.
Oh, nice. I love Anchorage.
I love it so far. It's been
But you missed our summer. We literally had that summer that
I know, I remember. So hopefully it clears up. I like to go.
Well, but we're not having early winter, it seems to me.
It's okay, I'm from Minnesota. I can handle the snow.
you're not scared. Yeah.
Well, nice to meet you guys.
So anyways, it's just interesting, and that's what I was saying. I wasn't trying to make a judgment. I was just trying to make a question.
Do you need a career?
I just take over you. Would you do me a favor?
I don't know, but I mean, the way I
Tuesday, I kind of figured that. I think it's, we have a work session.
How are you?
Hey, Tim.
Yes, sir.
I took yesterday and I did the food and power plant for AWW.
Yeah.
And I didn't know you had done it earlier this week.
Yeah, well, no.
Yeah, they said 20 years. I'm the second one this guy's ever seen.
Is that right?
Because you're the first one, so. Glad you did it.
It's a good tour.
It is, very good.
Are you recovered?
No. You?
Yeah, but I've got
Standing up for
to,
all that time.
I'm gonna be going until probably 9 o'clock tonight.
Really?
Yeah. Busy day.
Oh, yeah. I'm told four.
Worked very well.
Well, actually, I'm gonna go to that point.
That's what I'm hearing in contract.
Tonight.
I think I'm saying inspectors are actually not saying.
I planned it, my grandma.
Walk around or something, you show me around.
No, I hear it.
For the links and.
But if I do go, I'm gonna stay for a little bit.
I don't want to trespass without
You know Aaron, you've met Aaron.
Yeah, I knew that. That's why I was asking maybe, or if I could come with my kids. I would like to sit out there and actually watch the fight. Because I've driven there like 12 times.
There's parts that will be very different.
Well, it's very steep.
Yeah.
And my whole point is I wanted to get perspective from, year one, exactly. Because I've come there a lot, but I've never actually trespassed with this. Well, I was gonna say, yeah, they do, thanks.
But if you'd like a guided tour,
I would love one, because then you can kind of tell me, okay, this is where we expect this, this is the gravel pad.
I had it about, I have it.
That would be great, because I'm just trying to make sure I got it. The other thing I haven't asked them yet, but I'm actually gonna rest to solve it. They also do not. I just want to see the operation. Yeah, I figured they probably, I wouldn't just show up, I would call. Oh, of course.
But all the same principles apply, yeah.
Yeah, of course, but it was one of those things, I probably.
Well, yeah, I've heard that.
Every time you're going to
They're trying to refine it. They don't want to after it's passed, they'll call my doesn't surprise me. Doesn't surprise me. Well, when Andre submits plans under third party, how do you know it's they're hiding behind state law. It isn't that what they're saying is they're checking the application for compliance, which is an arbitrary term. It doesn't really mean it applies to define complete source. And what they actually say is, when you read the policy for industry, it says technician will check the application for completeness. And then stamp the plan approved. So on one hand, they say, our technicians are trained enough to know if something doesn't meet code. But as they're flipping through the application, if they see something that might not meet code, then guess what they do? They send it back to the plan review for further completeness check. And then when the reviewer looks at it and says, I just happen to see this section here, I don't think it fits code. Well, then I fall under state law that says, I can't knowingly stamp plans that don't.
I don't know if you speak in silver. I don't know if you
You know exactly what when the ordinance says these plans shall not be reviewed by any municipal parcel or send application to it. It says that in it. but then they circumvent it, find out the way, and they kick third-party planners and plans back to Hungary and say they do it. And you're, absolutely interesting. It's a game. They send it to the they send it to the building court, never once tell me about it. They take my word and send it over there. Never ask me to come and show me, explain it. And then I hear about the building board, and they say, oh man, I really wish that Mr. Tom was here to explain why he's doing this.
I put all the extras up there, sorry.
And you have Sharon Wolf push and say, you guys can call for a work session, you guys can make these changes. Sharon called for them, she's like, Sharon can't call for them. The board chair. She couldn't. Those are their actions in this. Thanks for listening to me. Man, I feel good.
It's not the boundaries you wish.
Well, I'm going to look at these recommendations and see what I can. Thanks, though. Appreciate you talking to that good.
My son's military.
How are you doing?
I got him. Oh. He says, this one, I said, no, I'm not going to get the he goes, I don't think I'm going to do something. I think this one was. This one was. Yeah.
No, this is too long.
This is too long. See, this is it.
I'll call the meeting back to order. And I'm going to move back over to Ms. Ray Jackson
Not at this time, thank you, Mr. Chairman.
and Mr. Trainee.
Question for Mr. Wheeler. I'm looking at this memo from Mark Madden dated December 29, 2009. In here he states, ideally we will have to pay 50% of the monies received from the land lease to Klutna. We request an opinion from legal as to whether 50% applies to land lease or could be extended to some or all of the project. The answer was a definite maybe. It says Ralph Dury is working on this. Did you guys submit a legal opinion on the status of that issue?
I don't know that we provided a written formal opinion, but I'm sure Ralph provided verbal advice to SWS.
Can you check and see if one was a written
Sure.
format? I'd like a copy of that.
I would like to, if you might, Mr. Chairman, point out that the conversation in both of these emails is about the obligation to share, if such exists, the revenue stream from the lease. It doesn't talk about the revenue stream from the sale of the gas. So there is a distinction.
Mr. Chairman, if I may,
Yes. Mr.
that's
Chair-
one of
Ray
the
Jackson.
reasons why I wanted to see the memo right away. Thank you. Thank you, Mr. Chairman.
Anything else? Mr. Trainee?
I want to see if Mr. Featherly, representing Klutna, has anything he'd like to say. Short period of time, Walt, because I've heard you before.
Thank you, Mr. Chair. Would you like me to be seated or stand or how?
However you're comfortable, Mr. Featherly. We prefer not lying. And by that, I mean on the floor.
Mr. Chair, members of the Assembly, Mr. Wheeler, members of the administration, thank you for the opportunity to address you. Some comments related to this work session here today. Klutna is, first of all, thanks in the Assembly for you giving attention to this issue. This is an issue that, as you can imagine, is important to Eklutna, not only because of the magnitude of the dollars that are involved, but also because of the profile of the issue and the effect and the meaning that it has in the relationship that Eklutna and the municipality have to the lands underlying a portion of J-Bear. These are and these will be long into the future a critical part, maybe even eventually a defining part of the relationship between Eklutna and the municipality of Anchorage, because of the unique nature of the North Anchorage Land Agreement, which in effect makes Eklutna and the municipality partners, potentially future partners, with respect to the ownership and development of those lands. So again, I just want to thank members of the Assembly for giving your attention to this, because this is an issue important not only for today, not only for this issue. This is an issue that's important is important for the future and for a very long future. In December of 2011, Eklutna wrote a letter to the mayor, and in the letter made a specific request to the administration for a proposal as to how the municipality envisioned that the proceeds from this methane gas waste recovery project would be shared with Eklutna. That was in 2011, in December. The response was from Mr. Dwyer, a legal argument that over the interpretation of the language that Mr. Wheeler has addressed, in which, without definitively saying so, in essence said, no, we don't interpret NALA as meaning that we have any obligation to you whatsoever, without actually ever addressing the requirement that is contained in NALA that the parties, meaning the municipality and Eklutna, meet regularly, not just periodically, but meet regularly to talk about issues, development issues with respect to these NALA lands. In September of 2012, I wrote a letter back to Mr. Dwyer, detailed letter explaining Eklutna's interpretation of this language and why, in Eklutna's view, the language requires the municipality to share either 50% of the net proceeds from the sale of the gas, or alternatively, if the municipality and municipal attorney's argument or interpretation is accepted, which is that the gas is produced from an improvement, it's attributable to the improvement on the land, i.e. the garbage, then the equivalent of the rent for the ground on which the garbage sits. NALA does not envision or permit the municipality to put the property to income producing use and avoid sharing any of the proceeds with Eklutna simply by electing not to lease the ground to a third-party developer to develop a sports stadium, a shopping mall, or a gas-producing facility, but rather choose to construct those improvements itself and then tell Eklutna you're entitled to nothing, which is the position that the municipal attorney has been taking. Rather, if the municipality chooses to develop the property itself, then there is a deemed ground lease. And that is acknowledged by Mr. Madden in those emails. That you take what the value of the ground lease would be if, in fact, the fair market value would be if this project, if they had gone the route that they were intending to go, which was to lease the project, or at one time we're considering going, lease the facility, lease the ground to some third party to come in and develop the project, build the gas processing plant and the transmission and distribution. NALA was carefully drafted and the words were carefully written in order to avoid the municipality doing exactly what Mr. Wheeler and the legal department is outlining as apparently the municipality's position, which is we'll just build it ourselves, and if we build it ourselves, we owe Eklutna nothing. In September 19th, to Mr. Trombley's question about is there any way other than litigation? Clearly, the lawyers have different interpretations. That's not, I wouldn't expect anything different. Lawyers, after all, their role in life is to take positions for the maximum benefit that benefit their own client. What Eklutna has repeatedly done is to reach out over and above the disagreement between the lawyers as to the legal interpretation, and reach out to the municipality and say, as effective partners in this deal, can you please provide the resources, provide the information, provide the personnel to come to us with a good faith proposal as to how you think this matter can be resolved between us. And in September of 2012, about 9 months after Mr. McQueen wrote the letter, the initial letter to the administration asking for such a proposal, I wrote back to Mr. Dwyer and said again, Eklutna reiterates its request that the municipality craft a fair and reasonable proposal that would meet the plain meaning and spirit of NALA relating to the income sharing provisions of NALA. That is the route that has been available, that Eklutna has been asking for now over almost 2 years, or a year and a half, more than a year and a half. Please sit down with us in a transparent way with an open book. Let's go through, look at the numbers. Let's taking into account the interpretations of the lawyers, taking into account the private assessment that the lawyers are giving as to the risks of outcome of the litigation, and let's come up with a fair, reasonable settlement. That has not happened to date. Eklutna hopes that it will happen, but I must tell you that the time is running out on that being able to occur before a lawsuit. Why? Because there's a statute of limitations that does apply to Eklutna's claim here. And Eklutna cannot afford, this claim is too important, too large, and too important to future interpretations and the future relationships with respect to these J-Bear lands, to sit on its hands and do nothing and allow the statute of limitations to pass. So thank you again for allowing me, on behalf of Eklutna and the Eklutna board members who are here today, to articulate their position and to again ask, knock on the door, please sit down with us, lawyers in the room, engineers in the room, politicians in the room, everybody who needs to be in the room, or at whatever times that they need to. Let's get this resolved, and let's come up with a resolution that is, maybe it's not a whole loaf for everybody. That was the spirit of NALA itself, to avoid a winner-take-all situation. Please, let's do it again. Thank you very much.
Mr. Filler, I've got Mr. Grady, or Mr. Trombley, Ms. Gray Jackson, Ms. Dembowski. Mr. Trombley?
Well, I can't order you guys what to do, but it sounds like to me that there is some room to at least come together and possibly at least have that discussion. Does a non-binding mediation sound like a good path forward possibly, in which the results come to the assembly and the assembly either sets some sort of policy or kind of makes a decision? Is that something that, and you don't have to say it now, but is that something that would be at least open to the idea of?
The Klutna's door is open and ears are open for any constructive suggestion for an avenue or proposal, absolutely, including that.
I guess you don't have to say anything, Dennis, but ideally that's something that I would like to see. I just want to avoid the.
I want to try to move quickly. I'm running out of time. Ms. Gray Jackson.
Thank you, Mr. Chairman, and thank you, Mr. Fabry, for your presentation. But here's what I think I heard you say, and of course, correct me if I'm wrong. Klutna's fair share is 50% of the net proceeds from the sale of gas, or if gas is an improvement, the rent for the ground. That's what I think I heard you say.
Yes.
So, are you saying that Klutna is willing to accept one or the other?
No, I'm not.
Okay, that's why I'm asking.
Thank you for asking for that clarification. The Klutna's position is that at a minimum, we're entitled to one or the other. The question either will be resolved by the courts as to which we're entitled to, or it can be resolved by discussion and amicable agreement between the parties. But thank you for the question, for allowing me to clarify. No, I'm not saying that would be acceptable as an alternative. It might be, might be the outcome of discussions, and the parties reaching an agreement. That might be a basis upon which to form the agreement is, okay, we'll accept that. But that's got to come through negotiations.
Right, and I totally understand. That's why I wanted you to express what you had to say again. And I have one question for you, Mr. Wheeler. Is it the city's position that we owe Klutna nothing right now?
That is correct.
Okay, thank you.
For two reasons. Not only that...
Mr. Flynn, would you please come in and join us? I want to show you at least getting here.
We've been waiting for an hour, Mr. Flynn.
But he's been standing in the doorway.
I know.
Are you done, Ms.?
No,
If I might.
not done.
Oh, yes.
For two reasons. First, the question of whether or not the income is attributable to the land or the improvements. But more importantly, perhaps, is the language that focuses on net income. And there's another large dispute here that we haven't spent much time on today, and that is our position that net income needs to take a large view. You have this landfill that has an unfunded liability as far as care and closure to take into account, as well as all the other operational costs with the landfill. This is part and parcel of that. My understanding of the Klutna's position is that they want to focus on the narrow income stream of the sale of the gas versus the expenses of perhaps just piping the gas out. We think that's too narrow of a view.
If I may, Mr. Chairman, so I guess, we've been hearing the term since the last meeting, friendly lawsuit. I guess it's definitely not going to be a friendly lawsuit. Thank you, Mr. Chairman.
Ms. Kembowski.
Mr. Wheeler answered one of my questions, but the other part, I just wanted to be very clear.
Yeah.
Who owns the land the landfill's on?
The municipality does.
Okay, so if the municipality owns the land, if it's found that this has been an improvement, the municipality made the gas, how would the Klutna be entitled to 50%? Or how would they be entitled to the lease of that land?
Yes, thank you for that question. Because the land is designated within NALA as being public interest land. The municipality owns it, but can use it only for public interest purposes. And the reason, the language that we have been discussing here today is the gate, if you will, on the back door that the framers of NALA put in place to say that designation isn't just for one time. Okay, it's public interest land. It's put to public interest use, and then later the municipality decides, we're going to do something else with it. Once they open that door and put it to, quote, income-producing use, then it goes back into the bucket of lands to which the Clutina municipality must share 50/50. So thank you for that
Thank you
question.
for that clarification.
And with that, we appreciate all of you coming to visit us. We certainly enjoyed coming out to Eagle River to have a visit with you. And with that, I'm going to close this work session, and we will start the other one as quickly as we can get set up for it. Thank you.
Thank you, Mr. Chairman.
Special meeting.
Adjourn.
I'm sorry.
Second.
Thank you.